Hi, this is Elina Gilbert. I am an attorney and a partner here at Heinemann Sanchez. The topic of today's video is going to be document amendments and how to know whether you need to amend. It's important for us to note that when we say document amendments, for the purpose of this video, we mean complete rewrites and drafting of brand new documents for your governing documents. And governing documents is really three essential documents that you work with. The biggest is your declaration, which is also known as your covenants, your CC&Rs, your declaration of covenants, conditions, and restrictions. However you choose to call it, it is the same document. The other two documents that are typically rewritten in conjunction with the declaration are your bylaws and articles of incorporation. The reason we want to rewrite all three at the same time is because the ultimate goal is for there not to be any overlap in the documents and for them to really complement each other and to work off each other. And that can only be done if we do all three at the same time. So what's required when you amend your documents? The specific provisions as far as approval from homeowners and the exact number are going to be contained in each of those documents. As a general rule, when you are amending your declaration, you will need approval from anywhere between 51 to 67% of all the homeowners in your community. When it comes to your articles and your bylaws, the requirements are usually far less stringent and are usually something like a majority or 67% of a quorum of homeowners. So it is, of course, easier to amend your articles and your bylaws than your covenants, but we do have some statutory provisions that assist us if we can't reach that 51 to 67% goal. Unfortunately, we don't have enough time in this video to discuss that particular process, but do realize there are processes out there to assist us. So the big question typically is, how do we know if we need to amend our governing documents? Well, obviously you want to have an attorney review them and tell you. But there's a list of red flags, and if you have one or more of these, then you should consider at least consulting with an attorney to get an opinion as to whether you need to rewrite your documents. I'd like to go through each of those red flags and get you familiar with each one. The first one is rather easy. It's the age of your documents. Is your declaration more than 10 years old? If it is, then you most likely will need to rewrite it because so many additional laws have come into existence in the last 10 years. We've had all sorts of Senate bills and House bills that have been passed and have revised the various statutes, and that alone is enough to require revision of your governing documents. Do you have language in your governing documents that references the declarant, which is the same thing as the developer? You might if you've never revised your documents. And if your community is already more than 5 to 10 years old, you've probably gotten rid of the developer and they're no longer involved in the community. If that's the case, that's a red flag for you that you may need to update your documents to get rid of that extra language. Another red flag is, can you understand your documents? Probably not. Most documents do have a fair amount of legalese, and there's really no way around some of that. But if you're looking at your documents and you have to consult with your legal counsel every time you're trying to figure out who has to maintain or insure something or what rights you have with respect to your assessment collections, then there is likely a problem. And the best way to address that problem really is to have your documents rewritten in a more clear and concise manner. Do you have overlap in your documents where your declaration and your bylaws may be talking about the same thing? Or there's a conflicting provision when they're talking about the same thing. For example, your declaration says you can only increase assessments by 5% every year, and your bylaws have a provision that say you can increase assessments up to 10% every year. That's a problem too. If you're seeing provisions like that, that is a big red flag. So really, you need to take a look at your documents and see what kind of problems you're having with it. The one last one I want to talk about is if the actual restrictions in your covenants still apply to your community. So often we see outdated restrictions that may have applied to a community when it was first created, but as the years went on, became outdated and don't apply anymore. For example, some communities may have a provision that says no pickup trucks in the community. Well, maybe when the community first came into existence, that was a valid provision. But now when you look around, you see that almost every person has a pickup truck in their driveway. That might be a problem as well. It might be time to consider rewriting your restrictions to actually more conform with what your community is now rather than what it was before. For additional information with respect to document amendments, red flags, processes, please visit our website and feel free to download any of the articles that you find. Thank you.